I'm reading from California Civil Procedure Handbook Rules, Selected Statutes and Cases, and Comparative Analysis. And I'm of the opinion we're in the intervention part C of chapter 5, joinder of parties and claims. That sounds right. For permissive intervention, the first subject we'll read is a case called Bus Stop v. Superior Court, Court of Appeal of California, 2nd Appellate District. The court gave the following opinion. In August of 1963, the case of Mary Ellen Crawford, a minor, by Ellen Crawford, her guardian ad litem, et al., plaintiffs versus Board of Education of the City of Los Angeles, defendant, was instituted in the Superior Court of Los Angeles County. That action was aimed at correcting the alleged existence of racial segregation in the defendant's school district. In 1976, the California Supreme Court filed its opinion in that case, Crawford v. Board of Education, 17 Cal 3D 280, affirming the trial court's determination that the defendant district was in fact segregated. The court also affirmed the trial court's order directing the plaintiff to prepare and implement a reasonably feasible desegregation plan. Subsequently, defendant district undertook the political process of developing a, quote, plan for the integration of pupils in the Los Angeles Unified School District, end quote, the plan. The record before us does not delineate in detail the procedural steps in that process, but we are informed by the parties that citizens as well as staff participation was involved and that divergent recommendations were received and considered. The ultimate responsibility of promulgating the plan was that of the elected members of the school board, and the wisdom of their proposal is, of course, in the political process subject to the scrutiny and reactions of their constituents. The adequacy of the plan vis-a-vis the mandate of the court is subject to the scrutiny of the court. The plan was submitted to the Superior Court of Los Angeles County on March 18, 1977, and the issue of its adequacy is currently being litigated. Again, we are not provided with the details of the plan except to the extent that the parties concede that the plan contemplates a certain amount of mandatory reassignment of students to schools other than their so-called neighborhood schools, i.e. schools in the area in which they reside. Prior to the presentation of the plan, petitioner Bus Stop, a nonprofit corporation, petitioned for leave to intervene in the action pursuant to Section 387 of the Code of Civil Procedure. That action provides in part that any time before trial, any person who has an interest in the matter in litigation or in the success of either of the parties or an interest against both may intervene in an action or proceeding. So, that's the definition we're going with, right, of what is permissive intervention from Section 387 of the Code of Civil Procedure. And that's the point of reading this case. This is one of the seminal cases in the state, using the state's Code of Civil Procedure that provides at any time before trial, any person who has an interest in the matter in litigation or in the success of either of the parties or an interest against both may intervene in the action or proceeding. Now, Bus Stop is an organization with a membership of 6,500 parents, predominantly white, residing within the Los Angeles Unified School District. That's a lot of people. The organization's prime objective is the prevention of mandatory reassignment of students to schools other than those which they now attend or choose to attend. The trial court by minute order entered March 14, 1977, denied Bus Stop's petition. Bus Stop petitioned this court for a writ of mandate to compel the trial court to permit intervention. We granted an alternative writ. Bus Stop's proposed complaint in the intervention alleges, and correctly so, that the Supreme Court, in its opinion in Crawford Supra, did not require mandatory reassignment of students as a necessary element of any plan. For that matter, the court did not set forth any specific requirements, but did state at page 360, in our view, reliance on the judgment of local school boards in choosing between alternative desegregation strategies holds society's best hope for the formulation and implementation of desegregation plans which will actually achieve the ultimate constitutional objective. Plaintiffs and the defendant district both oppose intervention by Bus Stop. They concede, and we agree, that Bus Stop represents a point of view which is entitled to and which should be heard and considered. The point of departure is the forum in which that hearing consideration should take place. The district's contention is that the point of view we considered in the political process of formulating the plan, but that now the issue is whether the plan will satisfy the court and not whether the plan is acceptable to the various elements that make up the district's constituency. The trial court's order denying intervention followed the position of the district. That order recites as follows. This case is now on remand to this court with a specific direction that it first look to the plans that were to be formulated by the board to ensure that the plans presented and filed with this court by the respondent have met the constitutional standards in response to the mandate. Therefore, within that frame of reference, the stated function of this court in the portion of the proceedings is limited. There is not at the present time the necessity or requirement that the broad equity powers inherent in this court for the enforcement of injunction or mandate decrees should be called into play. End quote. The trial court's order further says that it is entered without prejudice to renew the motions if, at a later stage, the function of the court should be radically changed. End quote. The district's objection to intervention is further based on the arguments that 1. The district represent all the residents of the district, and 2. That it permit Bus Stop to intervene would open the way for a multitude of other individuals and groups to also intervene. For their part, plaintiffs argue that the requirement of Code of Civil Procedure Section 387 are not met by Bus Stop, and that the organization has no direct interest in the outcome since no student has a right to remain assigned to any particular school, and that any reassignment as a result of this litigation would only be an indirect consequence of an order designed to protect the interests of the minority students. We are of the opinion that facially, Bus Stop satisfy the requirements of the Code of Civil Procedure Section 387 in its petition to intervene. Its members and the persons whom it purports to represent do have an interest in the litigation. As we stated in Johnson v. San Francisco Unified School District, 9th Circuit, 1974, all students and parents, whatever their race, have an interest in the sound educational system and in the operation of that system in accordance with the law. That interest is surely no less significant, whereas here it is entangled with the constitutional claims of a racially defined class. Certainly, the reassignment of students to schools distant from their residences would have a direct social, educational, and economic impact on the students so reassigned and their parents. This interest of those persons represented by Bus Stop is not presently represented by the parties to the action. The plaintiffs admittedly represent only the interest of specific minority students. Counsel for the district frankly admitted on oral argument that the district opposed the intervention because Bus Stop's interpretation of the Crawford decision is contrary to that of the district's interpretation, and in effect the position of the two were opposing. While conceding that Crawford does not mandate reassignment or busing of students, the district contends as a practical matter that compliance with the court mandate requires it. Bus Stop disagrees. In Johnson v. San Francisco Unified School District, Supra, parents of elementary school children of Chinese ancestry sought to intervene in an action involving the compulsory reassignment of students in San Francisco to schools outside the area of their residences in order to achieve integration of black students into predominantly white schools. They claimed that such reassignment would impinge on the cultural and educational interests of the Chinese community and that they should be entitled to participate in fashioning any desegregation decree. The United States Circuit Court of Appeals agreed. We find that case on principle to be indistinguishable from the case before us. In answer to the argument that the school board represented all of the district, the court there said at page 354, we cannot agree that the school district, which is charged with the representation of all parents within the district and which authored the very plan which appellants claim impairs their interests, adequately represents appellants. The district's fear that bus stops intervention may lead to a proliferation of interveners is unfounded. Further intervention can easily be limited by permitting additional intervention only by persons or groups whose interest is presently unrepresented in the action. Nor would the intervention of bus stops necessitate any duplication of evidence or repetition of proceedings heretofore conducted, while bus stop may recall witnesses for cross-examination or present its own evidence. It must take the proceedings as it finds them at the time of intervention. This includes the qualification of the trial judge and precludes any right to disqualify him pursuant to Code of Civil Procedure Section 170.6. Bus stop does not and has not challenged the original finding in this case that the schools of the district are segregated, nor does it seek to challenge the principle that the district has a legal responsibility to take action to alleviate that condition. Hence, the trial of the matter for all practical purposes began when the proceedings aimed at obtaining court approval of the plan. Bus stop's petition to intervene was filed prior to that time and was therefore timely. Finally, we reach the issue of the trial court's discretion in refusing to permit intervention. We agree with the trial court statements in its minute order, which delineates a limited role for the court in these proceedings, in which opines that the input of various constituencies should be confined to the political process. As we view it, the single issue before the trial court at this time is whether the plan satisfies the requirements of the decision of the Supreme Court ruling in Crawford. Apropos of that concept is the Supreme Court's language in Crawford v. Board of Education Supra, so long, quoting from 17 Cal. 3D280, so long as a local school board initiates and implements reasonably feasible steps to alleviate school segregation in its district, and so long as such steps produce meaningful progress in the alleviation of such segregation and its harmful consequences, we do not believe the judiciary should intervene in the desegregation process. Under such circumstances, a court thus should not step in, even if it believes that alternative desegregation techniques may produce more rapid desegregation in the school district. So long as the litigation remains in the posture envisioned by the trial judge, and the role of bus stop as an intervener may be limited by rulings on the admissibility of proffered evidence. However, looking in the background is the language in Crawford at page 307, quote, if, however, a court finds that a local school board has not implemented such a course of action, the court is left with no alternative but to intervene. Faced with a recalcitrant or intractable school board, a trial court may exercise broad equitable powers in formulating and supervising a plan, end quote. The history of performance of trial and appellate courts in this country and involvement with the operation of schools and school districts, unfortunately, has too often been one of over-involvement rather than restraint. We have no way of predicting what turn the present litigation may take, and while the trial court's order is a model of judicial restraint, it suggests the possibility that downstream the picture may change. In the interest of fairness and to ensure the maximum involvement by all responsible interested and affected persons, we believe that the proper exercise of discretion would have been to permit bus stop, representing as it does a proper and legitimate interest, to participate in the fashioning of any decree which may result in the mandatory reassignment of busing of students. Let a peremptory writ of mandate issue directing the trial court to grant bus stop's petition to intervene. The alternative writ is discharged. Now, the notes and questions regarding the permissive intervention case I just read and permissive intervention as a whole are two-part. So the first part is about direct interest and the second part is about discretion. Within direct interest, we'll have an A and B to read. So, Code of Civil Procedure Section 387A provides that any interested person may intervene in an action. The California courts interpret this broad authority to permit intervention to include several limitations. One is that the intervener's interest must not already be represented by existing parties. Must have came together afterwards, because it really doesn't sound like it's part of this case or part of the code, but it's something that I know is a requirement. Another is that the intervener's interest must be direct and immediate and not indirect and consequential. In other words, as one court explained, the interest must be of such direct and immediate character that the intervener will either gain or lose by the direct legal operation and effect of the judgment. So, some of this terminology is like critical in today's civil litigation. So, I'm going to highlight these words. Direct and immediate versus indirect and consequential. The quote I just gave is from Knight vs. Elifoso, which said, must be of such direct and immediate character that the intervener will either gain or lose by the direct legal operation and effect of the judgment. Which means that, like, San Francisco Unified can intervene in LA Unified because the same exact judgment is going to be applied to the reevaluation of their plan. And other examples, obviously. Whether the intervener's interest is sufficiently direct must be decided on the facts of each case. See Simpson Redwood Co. v. State of California, which analyzes several factors and holding that a group interested in preservation of old-growth redwoods should be permitted to intervene in quiet title action regarding boundaries of a state park. That's then there's also Highland Development Co. v. City of Los Angeles, concluding that some but not all groups opposed to the construction of an apartment building adjacent to a historical district possess the requisite direct interest for the intervention in litigation between the developer and the city over the right to a city construction permit. However, the intervener need neither claim a pecuniary interest nor a specific legal or equitable interest in the subject matter of the litigation. Simpson, Supra, and CCP 387A should be liberally construed in favor of litigation. I'm going to highlight here liberally construed in favor of litigation. But the other thing worth highlighting is that the limitation that the intervener's interest must not already be represented by existing parties. So you kind of have to pick the best intervener, assuming that the interests are the same as between multiple interested potential interveners. The bus stop court held that a group of white parents opposed to mandatory busing of students had sufficient interest in a sound education system and in operation of that system in accordance with the law to permit intervention, end quote, to permit intervention in an action where a school district was required to formulate a desegregation plan, period. Such plan would have a direct social, educational, and economic impact on all students and parents in the district. Based on this broad view of direct and immediate interest, what other political action groups could be permitted to intervene in this desegregation litigation? What limitations are there on intervention by such groups? So, like, anyhow, I was just thinking about, like, a school bus, like, service provider. But I'm not going to go there. It's a rhetorical question. B, after the appellate ruling in Bus Stop, another organization entitled BEST, Better Education for Students Today, also sought intervention in the trial court. BEST complaint and intervention disavowed any position towards any integration plan, but asserted that its members were well-intentioned citizens who would certainly have developed positions on the issues by the time they got to court, should BEST be permitted to intervene. For criticism of the reasoning in Bus Stop as an improper extension of the permissive intervention statute, see Stephen C. Yeasel, Intervention of and the Idea of Litigation, a commentary in the Los Angeles school case. So, the thing about BEST is no one can answer because BEST's interests, like the parties making up that group are not identified. Well-intentioned citizens, members were well-intentioned citizens, is not showing a true interest in the case. Well-intentioned citizens is just not enough. We don't know if they have kids in the school district, and that's kind of a mandatory requirement to have an interest in, some direct social, educational, or economic impact. Or interest has to be either advanced or diminished by the action. Well, let's read the definition one more time. It's kind of shorter here in the notes. It said, any interested person may intervene in the action. So, interested isn't something that we know that well-intentioned citizens are until they have some type of a right on the line. I'm moving on to part 2, discretion, which is the second part of being discussed of permissive intervention. In short, granting or denying leave to intervene under Section 387A is in the discretion of the trial court. And beyond bus stop, there's the citation for Lincoln National Life Insurance Co. versus State Board of Equalization from 1994. Unless a special statute prohibits intervention, the trial court's discretion to permit intervention should be liberally construed in favor of intervention. Even if the applicant establishes the requisite interest in the litigation, a trial court may deny permissive intervention. What factors did the court in bus stop consider in exercising this discretion? How did it apply these factors? So that was at the latter part of the case. It really wasn't at the beginning. If you want to read review and answer that question. Really has to do... why did it restrain itself? It just based it on precedent from the Crawford case. So intervention of right is the second part of this section, and we're going to read that because the next recording will be class actions all day. All day class action. So, intervention of right. In 1977, the legislature enacted CCP 387B, which added intervention of right to traditional permissive intervention. If any provision of law confers an unconditional right to intervene, or if the person seeking intervention claims an interest relating to the property or transaction which is the subject of the action, and that person is so situated that the disposition of the action may, as a practical matter, impair or impede that person's ability to protect that interest, unless that person's interest is adequately represented by existing parties, the court shall, upon timely application, permit that person to intervene. Section 387B is modeled after Rule 24A of the Federal Rules of Civil Procedure. Okay, it's modeled after the Federal Rules of Civil Procedure. Part D is all about class action. So I'm going to stop here because it's going to go on for 7 pages.